See that in arbitration in India is mostly ad hoc, unlike in US or European countries where it is institutionalized. When I say institutionalized, there are two types of arbitrations which has been held. In India, it is only ad hoc arbitration. Institutionalized arbitrations, which is the practice in Europe and US, Western countries, refer to adopted by ICC rules, mostly maybe you may be aware, International Chamber of Commerce, Paris. They conduct the arbitration, they select the panel of arbitrators, and they give the time frame within which the award has to be rendered. So in Europe, and there is a construction dispute which is involving millions or billions of dollars or euros and all that has been completed within a matter of 6 months, and the award is rendered. But of course, the cost aspect in the institutionalized arbitration like ICC is quite high. In the sense, supposing a contractor or a claimant, he is making a claim for more than about 10 million. Your arbitration cost is pegged based on your claim, which means in the result they wanted to discourage making a frivolous claim. That is the idea behind it. Then they appoint an arbitrator, and once that award has been rendered, it does not directly come to the parties, but it is given to the secretariat. They go through that award, whether there is any error apparent on the face of record, they just go through and rectify, then only it is published. Once it is published, it can be enforced in any part of the world, provided that country is also signatory to New York Convention. Apart from that ICC, there are other three. One is Singapore International Arbitration Center, which is quite competitively cheaper when compared to ICC. A lot of Indian companies as well as South Asian companies working here from abroad, they adopt that SAAC. You can go to the website, you can also become qualified arbitrator, provided there is certain norms, you have to write an exam and all that, and you will be enrolled as an arbitrator. SAAC, in consultation or in collaboration with CIDC, Construction Industry Dispute Council, which is based in Delhi, they conduct this arbitral, they wanted to know, create arbitrators, certain aspects to a level of international standard, which ICC does. So every year they keep on conducting programs, which you can also check up with CIDC in Delhi or otherwise SIAC. They conduct almost about 2 to 3 programs in a year, and they empanel arbitrators throughout the world. When compared to ICC, SIAC, Singapore International Arbitration Center is quite cheaper, almost about 30 to 35% in cost. And they also opened a center here where the institutionalized arbitration can be conducted either in Bombay or in Delhi. They have created that infrastructure. Similarly, there is another one, is London International Council of Arbitration, LCIA. They also opened a center in Delhi as well as Bombay. You can also become a member. There is a website which is available. And they also conduct similar programs and train arbitrators. LCIA does not follow certain procedures, but whether it is UNCITRAL model rules or Indian Arbitration Act or some other jurisdiction, they adopt the same thing. But when compared to the cost, between ICC, London Council of International Arbitration, is somewhat competitively priced. Not major difference. And yet another one more is there is American Arbitration Association. Quite a lot of people from India is also qualified. When you join the AAA, American Arbitration Association, you can also become a member of Dispute Review Board, they call it. That means it's a prelude to arbitration. Any disputes which are all settled, can be settled across the table, they refer to Dispute Review Board or Dispute Adjudication Board. And they also conduct similar training programs to train people, like, supposing if it is a technical matters is involved, they train engineers, like, construction specialists, or if they are in finance, they train this finance, and they appoint those people for review of the disputes. This is in general. So once that is the dispute reviews and goes through this, they give the recommendation. It is not become, it is an award, it cannot be enforced. But once the both parties agree, then it becomes a binding award. For example, World Bank in the past, World Bank or Asian Development Bank, or for example, Japanese International Cooperation Agency like JICA, and you can see this metro which is being constructed in Chennai. This is wholly funded by JICA funding. And they insist that standard contract documents has to be followed. And one of the reasons in those contract documents is some disputes arises between the contractor and the client, or vis-a-vis subcontractors or consultants or design specialists. It has to be first settled a process through a dispute adjudication board or dispute review board. You cannot elevate this again directly to arbitration. Once that is settled, and if they are able to narrow down that issues, and still if the dispute review board, one of the parties is not happy or they don't want to accept that recommendation, then finally after a completion of particular time limit, say about 56 days or is been mentioned, you can go for arbitration. But all this process has to be followed in all this multilateral funding agency like World Bank, ADB or JICA, whatever it is. This is to ensure that why they are making is there should not be any disputes. It has to be narrowed down. And you should not make a frivolous claim just for the heck of it. For example, in an arbitration, you may be knowing that most of them are lawyers. I invoke arbitration. Okay, there is a dispute. That doesn't end there. Then immediately I move under Section 9 and asking for interim relief. Or for some example, I am questioning that where the jurisdiction is. I go to this high court, that high court, and all that, so many things. These are all the delay tactics which the litigant does. Most of them may be thinking that arbitration is quite cheap compared to your litigation before the court. But conversely, it is quite costly. For example, I told you, in NHA arbitration, which starts from about today, it takes about another 10 years for you to realize. But at the time of realization, what is the value of your money? At that point of time, your client will negotiate with you, okay, I will not pay you that interest. You're trying to come down and compromise or waive your right. So these are all the fallacies in that arbitration which is being conducted in India for the particular reason, they don't honor. Arbitration as such is being provided so that the dispute could be settled as soon as possible, and principles of natural justice has to be adopted. But unfortunately, some of the litigants, though there is an arbitration, they took it to that highest level, and in that process, both parties to the arbitration suffer in terms of time, in terms of cost. And there is one more arbitration, institutionalized arbitration here is Nani Palkiwala Association, which you may be knowing somewhere in Las Mylapore. They also conduct, they have a set of procedures. And you have a fast track arbitration and regular arbitration like in FICCI in Delhi. For maritime cases, it all started from the maritime cases. FICCIs have two types of arbitration. One is fast track and another is regular arbitration. There's confined primarily earlier those days for only disputes related to maritime, but slowly it got expanded. So that is the situation in India, but arbitration as such, supposing you have a passion or to specialize, to do further on this, you have to be trained, not only in India, but also in other international arbitration, institutionalized arbitration process is slowly coming in. It is a matter of time in next 2 or maybe 5 years when ultimately India has to sign the WTO. They have to align with this. So the institutionalized arbitration, which has to be in place, maybe, though not in the near future, maybe in a matter of 5 years or 8 years. So please align yourselves so that you will be trained as a long-term goal, so that everyone, like multinational corporation who are coming to India and other construction companies or so many companies, they only look at the experience what you have. It is not an ad hoc arbitration which is being conducted in India as of now. That is not going to help. But the institutionalized arbitration, which has got a future, that is what is going to help you. For not only us, for all the corporates. I brought some the procedure like institution and other what to do, but unfortunately there is a problem. That only thing is I will share some of the case laws which has been rendered recently. Construction people as an in-house. L&T has got more than about 75,000 employees, of which construction sector we have about more than 35. Project size of more than 520 as of today in India as well as abroad. And these engineers has to be trained in different facets of arbitration, so we conduct that arbitration. So this is some of the major cases which the recent, the Bharat Aluminium, which has been overruled by that Satyam Computers and all that, So we went for a larger bench. Supposing there is an arbitration which has been conducted elsewhere and an award has to be implemented or enforced in India, it says it can be. Earlier there was part 1 and part 2 in the Arbitration Act. Maybe Mr. He'll be able to, other faculty members will be able to brief you on that. I will leave it, you can take. I have a hard copy also. I don't want to read it, it is already there. This is on section 11, Sundaram Finance. It was a major case. This has went up to Supreme Court after this 1996 new act has been passed. And the recent cases is ONGC versus SOPAS. See, in one of the landmark case, on what grounds we can challenge an award given by a tribunal? There are certain provisions which has been given in the Act. Earlier you must have seen that what is the public policy? It's a misconduct on the arbitrator. Some of these. And that has been clubbed down under section 34, which we want to challenge this arbitral award. Only about 3 or 4 when the arbitrator exceeds the limit, that means he is beyond the contract. One. Second is against the public policy. What is the public policy? That has been detailed in this SOP types. Public policy is what against the laws of substantive laws of India. That is what it says. It has been overruled from, taken from Renu Sagar case earlier under the 1940 Act. And this is once, under the new Act, once if you want to challenge that arbitral award in the court, once you file it, it becomes, that stay is already there. That is what the Supreme Court says. Supposing a party wants to challenge that, once I file and it has been admitted, that means that stay is already there, unless the court revokes. That is a NALCO case. These are all some of the major cases which I thought I will share with you. Of course, one more stages of arbitration and institutionalized which I shared with you, though I got it, but unfortunately there is some problem in that USB. But I'll try to send it to Dr. Paul Chalakumar so that he will distribute to you. So if you have any other qualification, because I don't have further much time, though I would like to spend with you more, but unfortunately I have to go to office. It is in Ramapuram. It takes about almost an hour. So if you have any few clarification or question, you are most welcome. So if there is nothing, I would like to say thank you, and I'm just sharing whatever our experience. And in case if you want to, at some point of time, to some help or some cooperation, you are most welcome to get in touch with us. Thank you. All the best.
A very good morning to all. I firstly wish to thank Dr. Paul Chalakumar, the president of our institution, who has given me a wonderful opportunity to present 3 subjects, 3 major topics of the Arbitration and Conciliation Act 1996. Firstly, we will be dealing about the main objectives of the Act. With this, I would also make a brief introductions about the Arbitration and Conciliation Act. The Act is divided in 4 parts, wherein the first part deals with the arbitration. Second part, as Sir rightly pointed out about the enforcements of New York Convention, Geneva Conventions. Therefore, the awards, enforceability of awards is dealt under the second part. Thirdly, the conciliation. Fourthly, the miscellaneous provisions of the Act, in which the major part is the part 1, which contains several chapters. Each chapters are consecutively states about the various rules of conducting the arbitrations. What is the agreement? What is the purpose of the agreement? How the agreement should be followed by the appointments of arbitrators. Once the arbitrators are appointed, what would be the procedure in conducting the case? In the course of conducting the case, what would be the language that has to be followed in the entire course of proceedings? What would be the place of arbitration? What would be the time limit for both the parties to submit their disputes, their claims, their rival claims, etc. And in the course of proceedings, if the parties are still interested to settle their disputes in some other ways like conciliation, mediation, what would be the ultimate award, what would be the, how the award will be executed, entirely are dealt under the Arbitration Act, each and every part with each and every chapters. With this brief introductions, I would come to the subject of, firstly, what is arbitration? As per the Act, it is very simply stated, arbitration means any arbitration, whether or not administered by permanent arbitral institution. However, in simple words, arbitration is the disputing parties, that is, the party who are disputing can file applications or they make their submissions to a neutral person decided by them mutually or by the courts. For their ultimate disputes, either the said neutral persons will be one or more than one, but they will always be in an odd number. Secondly, the concept of arbitrators. The disputing party who accepts for the persons to decide their disputes are called as an arbitrators, and who will be the said parties will be detailedly discussed, and any person can become the arbitrators from any part of the life, any part of the field. A person may be an advocate, person may be a student, a person may be a qualified civil engineer, person may be from any part of the field, because the only intention makes, the Act makes is the party must accept to become as an arbitrator, and they must accept that he is the person who should decide our dispute. He may be a relations to the parties, wherein generally when the family matters, a party who is most related to both the parties are act as an arbitrators. Likewise, any person who is a qualified in civil engineer, who will be well acquainted with the civil engineers and other technical aspects, will be decided, will be acted as an arbitrator. So it is the interest of the parties. The entire Act gives freedom to the parties who should be appointed in the arbitrator. The party has alone rights to decide. This is the entire object of the Act. Major object of the Act. With this, we are coming to the topic of objectives of the Act. What was the major object of passing this said enactment? When there was an earlier enactment of Arbitration Act 1940, as everyone are now well aware that the society has dynamically changed. A person now has his breakfast in Chennai, he can have lunch in Calcutta, he can have his tiffin or break time of tea time in Delhi, and lunch and dinner at Bombay. Like that, any person can travel any part of the country, any part of the world in a span of a short span of a time. The advancement is in such a way that every person has accessible to any part of the country. In this rapid development, our Indian Arbitration Act 1940 was not meeting the requirements of the international standard. In these circumstances, as Sir rightly pointed out, the unsettled model law of arbitration, the United Nations Convention has recommended all the nations, all the parties who are signing the contract or who are the signatories of the United Nations Conventions, United Nations recommended to bring a legislation which is in consonance with the international commercial arbitration. Why there was a need? A party of one country, assuming a party is of an India and another party is of some other country other than India, Singapore, London, Malaysia, any of the parties, the other party to the disputing party would have a doubt whether ultimately if I win the case, ultimately in the case of a settlement arrived between the parties, whether I will be getting back my money from the party. What authority is there which will secure me from claiming my amount? Party wins assuming thousands and thousands of crores, and he don't have any security as to how to enforce against the said party and how I could recover the said money from the said Indian person. Therefore, there was a need and necessity for passing a legislation which meets the international standard. Thereby, the major object of the act was to enact the Indian Arbitration and Conciliation Act in the concept of unsettled model law, which is known as United Nations Conventions on International Trade Law. Secondly, object of the act is to minimize the burdens of the court and also the appeal. A party to the dispute, if ultimately goes to the court from the lower court, from